Okay, now I will bring up candidates for Group 17, which is Cherish Adams and Joy Goodyear. All right, we have a minute and 30 seconds, and this, like we did before, is for opening statements, and we'll start first with Ms. Adams.
All right, good afternoon, I think it is now. I'm Cherish Adams. I am serving as a county court judge and have been since 2023. I'm a proud member of the league, and I've had the honor of serving in both a civil division and a criminal division as a judge. I grew up in a working class home. Both of my parents are teachers and still are teachers here in Orange County. I'm honored to have had the privilege of serving as a judge. This is something that I had desired to do since I was a teenager. As a teenager, my best friend suffered a family tragedy as a result of gun violence, and I knew then that I wanted to be a lawyer. And so I pursued that, and I've dedicated my career to serving here in Orange County. I clerked for the 5th District Court of Appeal, and I served as a prosecutor here in Orange County in the 9th Judicial Circuit for over 9 years. In that time, I prosecuted sex crimes, violent crimes, and homicides. I have had over 80 jury trials, 67 as an attorney, and 17 as a presiding judge, and those were felony criminal jury trials that I presided over. I'm honored to be here today and look forward to the questions and hope to have your vote on or before August 18th.
All right, Ms. Goodyear.
Thank you for letting us come here today. This is a very valuable moment. I also am a member of the league and really appreciate all the work that you do. My name is Joy Goodyear. I have been a resident of Orange County for the past 26 years. Both my children were born and raised here. I was a Girl Scout leader and a track coach. As a child, I was raised by a single mom, a mom who had to work 3 jobs to help support our family. She taught me that the most important thing a person can have is empathy for others. She taught me to notice when other people were struggling and to help whenever I could. When I was in high school, I did a day of career shadowing with the Public Defender's Office. On that day, the attorney I was assigned to was covering county court arraignments. When we walked down to the courtroom, the lobby was filled with people, all waiting for their court date. They were scared, they were overwhelmed. I watched as the attorney called each name, and the person came up, explained their story, and the attorney answered their questions and helped them. I saw firsthand the relief they felt simply because someone took the time to listen. I was the first in my family to go to college. I then graduated from Stetson University and Stetson Law School and got a job with the Public Defender's Office, which I've been at for the past 28 years, fighting for those who have no one else to stand up for them. If elected to the bench, I will bring these experiences with me. I will remember that every case is unique, that every story deserves to be told, and that sometimes the solutions lie in solving problems beneath the surface. Thank you.
All right. And we'll start with Ms. Goodyear. Have you ever been arrested or had a client file with the Florida Bar a complaint or the Supreme Court taken any disciplinary action against you?
No, I've never been arrested, and I've never had a complaint filed.
Same to that, no.
Okay. All right, 1 minute. In county civil, most people don't have attorneys. How do you conduct a fair trial for people who are representing themselves? And so we'll start with you.
I think that's one of the reasons that I'm really looking forward to the opportunity to serve in county court. I really like working with people. I know as a judge you have to be really careful not to advocate for them and just make sure that they understand the process, and that's something that I would be able to do. Having represented individuals my entire career, that has kind of been my responsibility to kind of explain what's happening and the process. And I think as a judge, as long as they understand everything, then even in a civil court, you would be able to help them through that process without advocating for them, and if necessary, refer them to resources that could help them.
I've had the privilege of being able to do this. So I'm currently assigned to the civil division, and when I was first on the bench, my first assignment was in civil. So I have over a year of experience working with this, and you're correct. A lot of the litigants who come to county court don't have an attorney. They're there because somebody is trying to evict them and they can't pay their rent. So of course they can't pay an attorney. And when they come to court, it's a scary experience. They don't know what to expect. And so I start every hearing with a self-represented litigant by explaining the process. I explain to them first what we are there for that day, what we are not there for that day, and I explain what is going to happen during the hearing. I explain who is going to be speaking first, that each party will have an equal opportunity to be heard, and I explain that process so that everybody understands what is going to happen. You're right, not everybody who comes to court can win, right? Only one side usually is going to win a case unless we can reach an agreement. But my goal and my hope is that anybody, oh, I saw the stop sign.
Thank you. All right, Ms. Adams, this is 1 minute. In a courtroom, many times cases come down to two people telling two different stories. As a judge, how would you determine who is being truthful?
So some of this comes with experience, right? And being able to hear testimony. As a prosecutor, I presented testimony, I heard testimony from other people, and so I come into this with some level of common sense, right, that I'm applying to the testimony that I'm hearing. You also look at whether it is consistent with other evidence in the case. Did the party present any evidence to support it? If they're saying that they paid, do they have a receipt? Do they have a bank statement showing that they paid? And you consider somebody's demeanor. At the end of the day, there's one party, the plaintiff, who has the burden of proof in the case. And so if it comes down to you believe both of them equally or you don't think that the plaintiff has met their burden, then you're going to rule for the defense because it's the plaintiff's job to prove their case.
Ms. Goodyear.
Yes, I deal with this on a pretty regular basis because a lot of the cases we see are that. And my clients don't always understand that. They say, oh, this person's saying this about me, but it didn't happen, and they don't have any proof. And I tell them, well, their testimony is proof. Their testimony is evidence. So it can be enough. Obviously, we'd love for everything to be on film. We'd love there to be proof of everything, but that's just not the way it works. But the burden of proof is really important. You have to see which party has that burden of proof, and you need to be able to evaluate the testimony. Look at their demeanor, look at what they're saying, and look for inconsistencies. To me, that's the key thing. When someone's saying something that's not true, it's really hard to not have some inconsistency in the testimony. But the burden of proof would always, if it's a tie case, the burden of proof is going to decide it.
All right, thank you. 1 minute. County court deals with a broad range of issues such as breach of contract, evictions, criminal cases. And so, Ms. Goodyear, tell us what education and life experience you have had that will help you decide cases.
So as most attorneys, usually we specialize in one area. Obviously, I've been a public defender for 28 years, so my specialty is criminal law. That's what I do. However, I have taken several pro se cases. I've handled some landlord evictions and some small claims cases. So I do have some minor experience in civil law. But I think it's more the courtroom experience that really comes into play. I think being a public defender, being in court every single day, knowing the rules of evidence, knowing the roles of the other people in the court, like the clerk and the bailiff, I think those are really important. And I think I would rely on those experiences to guide me through whatever assignment I received.
So I have experience with both civil and criminal. So my background, I told you I clerked at the 5th District Court of Appeal. As a clerk, we handled all kinds of cases. Anything that was appealed to the 5th District, civil, criminal, family, all of those we handled. And so I clerked for a judge there for 2 years, handling all types of different cases. I then served as a prosecutor for just over 10 years, and I've tried a lot of criminal cases, so obviously I have that experience. But I also have experience as a judge handling civil cases. I didn't know civil before I came to the bench, and I had the experience of being able to learn civil and the unique rules and procedures that do apply to small claims and eviction cases that have a summary procedure, and being able to preside over hundreds, I think at this point, of non-jury trials and evidentiary hearings in civil, and that is where I'm currently assigned. So I have both experiences.
Okay. All right, a minute and 30 seconds, and this is the last question for this group. You preside over first appearances for people who were just arrested. What factors would you consider in a domestic violence case where a man beat up his wife? How would you set bail and conditions of release?
I have some unique experience with this because as a county court judge, this is a lot of what we do. And I was assigned for just over a year, closer to a year and a half, handling pretrial detention hearings in Orange County. So when individuals were arrested and they came to court on serious offenses, including serious domestic violence offenses, I was the one who would decide whether they could be released or whether they needed to be held pretrial detention. There are statutory factors that we can, there are statutory factors that we consider, and those include somebody's arrest history, the facts of the case, the arguments of the parties, which is important, whether the state is seeking pretrial detention or agreeing to release, and the victim's wishes. A lot of times in those cases, the victim appears and you can see them. You can see their appearance shortly after. Do they have marks on them? Do they have bruises on them? And what are the facts of the case? Was a weapon involved? And does that individual have a history of domestic violence offenses, and particularly offenses against that individual? So those are all the factors that I would consider in determining whether to set a bond, along obviously with the facts of the case.
All right, thank you.
So first appearance hearings are things that we rotate through our office. So I do them probably once every 2 months. And there are a lot of factors to consider, especially in a domestic case. So first of all, when it comes to you, all you have at that point is the police report for the most part. So you're reading the police report, you're reading what was said. It's mostly just people's statements. I very rarely have seen pictures or anything at that point. It's usually just the statements in the police report. So there are certain things that you follow by statute. You have to make sure there's probable cause. You have to make sure the elements were met. You also have a certain amount of bond that would apply. Like if it's a misdemeanor case, the bond may be like $1,000, but if it's maybe an aggravated charge, it's going to be more like $15,000. But so there are certain standards that we follow. In addition, domestic cases pose other problems. These people live together. They have maybe children together. So all of the belongings of the person are back at the house. But you don't want that person going back to the house and maybe having another dispute. So you need to do what's called a civil standby, which is where the sheriff can go with them and watch as they collect their belongings and get another place. You're also going to be issuing no contact orders, which are telling them that the parties shouldn't be in contact unless a future hearing is held where a judge can more have testimony come in, talk to the witnesses, and see in that particular situation what the best conditions should be. So there's a lot of different things to consider in a domestic type case.
All right, thank you. All right, thank you. Candidates, please return to your seats.